Good morning, and thank you for joining me on the Path to Liberty. It's Wednesday, July 1st, 2020, and on this episode, we're talking about how to read the Constitution. I know you guys have heard me talk about this in brief segments for months. I've gone all the way back to middle of last year and saw myself doing episodes where I talked about how I was going to put together a research guide. Because while it sounds logical and it seems very appealing to just say, read the document and apply common sense to the definitions of the words, it only guarantees, if you do it that way, it only guarantees that people who hold power are going to do the same and force their own personal views of what the words mean on anyone and everyone possible. So I'm going to share with you some steps on how to get the original legal meaning of any clause, word, phrase of the Constitution from people like Thomas Jefferson and, more prominently, James Madison. A few important examples from them. And then I also have 5 categories of original sources that you need for your research. And I'm going to include in the show notes at 10thamendmentcenter.com/path to liberty, all spelled out, links to all kinds of stuff that you can just go to. And we're going to do kind of a revamping of the homepage at 10thamendmentcenter.com sometime. And I'm making this promise publicly because I've been telling myself we need to do this for quite a while. We're going to do this sometime in the next few months before it gets crazy busy for the Christmas season and legislative sessions for 2021 and the like, and nullification. So we need to change this so it's very easy for people to go to our website and just say, okay, I want to look up such and such. And how do I do that? So we're going to provide links to all kinds of stuff on our website very, very soon. But first of all, before getting to all the details, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday. Well, except this last Monday, I needed a day off, actually, at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. We have a bunch of live streaming video channels, YouTube, Facebook, DLive, Twitch, Periscope, Twitter. As long as they allow us to keep going, we're going to keep spreading the message and reaching people where they are. We also have archive video versions on a number of alternative platforms like Library, LBRY, Library.tv, BitChute, BitTube, Brighteon.com, and probably elsewhere soon. We also have the audio-only podcast edition. That's iTunes, Spotify, Stitcher, Google Play, Podbean. You can find all of those platforms, all of the archives of the show. We've been doing it for about 2 years now. Links in each episode to stuff that I reference, especially this one. I've got all kinds of links to original sources where you can do research and learn for yourself rather than just listening to me saying, here's what you got to do. You can go do it and share information with me, and then maybe we can work on these things together and learn and educate others together, because that's a force multiplier. You can find links, you can find ways to follow us, the platforms, social media channels that we're on, and even our membership program where you can support us for as little as $2 a month, and we make it go a long, long way. We just celebrated our 14-year anniversary last week, and we're working towards another 14 years and millions of more people that we can teach about the Constitution and liberty. So thank you so much for any consideration you can give to that. Of course, that's all over on the show homepage that I just mentioned, 10thamendmentcenter.com/path to liberty. Again, 10thamendmentcenter.com/path to liberty. Looking over at the live chat, I just want to say hello to everyone really quick, and I appreciate you all being here, whether it's live or later on in the archives. I do read through all of them at almost every episode, and I reply to as many as possible. Hi to Funky Euphemism, Patricia Dance, Melody Skaman, Bob Landry, Timothy Martin, Ward Lawrence, good to see you. Blue North, good to see you. I appreciate you being on. I did a class with the Leadership Institute yesterday. I saw you there. I appreciate that. SAH Biochemist, Tyler B., Justin Bayola, Dean Stumpf, Taco Salad, Scott Mize, Kyle Reese over on Periscope. That's awesome. I don't know if I said funky euphemism, but you get a double just in case. Fuzzed T Fork, happy July 4th or Independence Day or Declaration Day, we can call it. Ryan Lopez, good to see you, buddy. And everyone else, I apologize if I missed you. There's Shane Lackey, Richard Banks, and Bob Brewer. Thank you so much for being here. Let's dive right to this. And I want to first start out with an article that we published last year, June 24th, 2019, from Mike Meharry. This is something that we should really be highlighting all the time. And he titled it, "The First Question We Should Always Ask." And here's how he started. And this just, I think, sets the foundation for what we're talking about here today. Here is the first question you should ask about any proposal made by any person in the federal government, or any politician, or any pundit, or any TV person, or YouTube personality, anybody. Anytime they're talking about the federal government should do blank. The first question is this authorized by the Constitution? Not, Mike writes, do I like this policy? Not, do I like the guy proposing this policy, or the girl, the person proposing this policy? And not even, is this policy a win for liberty? Because a lot of times, short-term wins for liberty are long-term losses, because what they've done is they've authorized additional centralized power, and when you consolidate, that's what the founders were so greatly concerned about over and over and over. When you consolidate power, eventually someone's going to use that power in bad ways. So short-term wins are like little handouts from the mafia to say, oh, okay, well, here, we're going to give you some breadcrumbs, and then we're going to use this in really bad ways in the future. So again, the first question should always be, is this constitutional? And if it's not, based on the original meaning of the Constitution as ratified, it shouldn't be done. Period. And that's a great article. I will link to that in the show notes. Let's go to James Madison's report of 1800. This is where he's talking about the Virginia resolutions of 1798, which called for interposition against the federal government, and the Alien and Sedition Acts signed by John Adams back when he turned into a bad guy. He says the same thing. Whenever, therefore, he's got two steps that we're supposed to take. First, whenever a question arises concerning the constitutionality of a particular power, the first question, just like what Meharry wrote, and I'm sure Meharry's really channeling Madison. It's not the other way around. I love Mike. He's really great, but he's no James Madison. Neither am I. The first question is whether the power be expressed in the Constitution. If it be, the question is decided. Is it there? Is it constitutional? The second question, we're going to get to this very briefly a little bit later in the show. If it not be expressed, Madison writes, the next enquiry must be whether it is properly an incident to an express power and necessary to its execution. And he's getting into the doctrine of principles and incidents. That is the necessary and proper clause, not how we are told the necessary. According to most people, the necessary and proper clause means they can do whatever is necessary and proper to accomplish their personal political goals. But that's not what it is. Madison specifically says whether it's properly an incident to an express power and necessary to its execution. If it be, it may be exercised by Congress. If it be not, Congress cannot exercise it. So we've got two steps. One, is it in the Constitution? Specifically, is it expressly delegated in the Constitution? And two, is it incidental? That's necessary and proper. So let's first look at the first step and see how it plays out when people approach it, how I talked about it at the outset. Just look at it, apply your own logical views of how things are, maybe modern definitions, hint, 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 where we're going on this, and see how it plays out under the Commerce Clause. And this is an article by Rob Natelson that we published over a decade ago, July 20th, 2009. We've been publishing since back in late 2006, early 2007, even though I registered the domain name in the summer of 2006. I had to learn a little WordPress before I really got things going, but this was in just the first couple of years. This is an article that Rob wrote called Claiming Almost Everything is Commerce. And he starts out, how can Congress get around the 10th Amendment and regulate almost every aspect of American life? We see that it's about regulating commercial activity, commerce among the several states. So how can they do anything? He says one way is by claiming that the 10th Amendment doesn't apply because Congress is merely acting within the scope of its enumerated powers. So they're saying, yeah, well, you know, they're not restricted from doing this Affordable Care Act or whatever it may be, because they have this Commerce Clause, and this Commerce Clause needs to be read broadly like such. He says to make this claim, one must assume that some of the enumerated powers are much broader than they really are, and this gets down to definitions and legal original understanding. So we have to be able to provide powerful arguments in response to this. And he talks about the necessary and proper clause, and Congress giving the having the authority to regulate commerce among the several states. And he says, according to promoters of the monster state. I love that phrase, and I've kind of adopted that myself. He says those constitutional phrases go further than allowing Congress to regulate trade among the states. They also allow Congress to control manufacturing, wages, agriculture, crime, mining, land use, firearm possession, and a range of other activities. Regulate commerce to them means control, ban, prohibit, mandate anything and everything. Rob asks, how do they justify this? And there's basically two arguments. The first one came during the New Deal by a University of Chicago law professor. This professor, Rob writes, argued that during the founding era, the word commerce meant more than trade. And we're going to get to that specific example in just a little bit. That commerce meant more than trade. So they've based this in the New Deal that commerce means more than trade. Instead, he contended that commerce included all gainful economic activities. Hence, Congress has a license to regulate the entire economy. I'm just going to give you a spoiler. Commerce meant trade at the time of the founding. It was ratified, given legal force by the people of the several states through their ratifying conventions under that understanding of the document. And being an 18th century legal document, like any other legal document, it has the same legal force today as it was understood to have at the moment it was given legal force. Rob goes on. An even broader version of this theory was published more recently by a Yale law professor. He maintains that commerce means any human interaction. So any human interaction is commerce, saying hello, a handshake if you're allowed to do that, a hug. So the federal government can regulate almost anything so long as it doesn't trample one of the specific guarantees in the Constitution, such as free speech. And Rob sums this up, and I'll get right to the more detailed stuff here in just a moment. On investigation, however, the claim that commerce meant all gainful activities or all interactions turns out to be completely untrue. He and another leading legal professor, original constitutional scholar, Randy Barnett, both of these guys I find really good research from. I don't agree with all of their prescriptions, their recommendations for how to deal with federal overreach, but they do very good research, and it really makes me think. And these two guys Barnett and Madison researched the use of the word commerce thousands and thousands of times at the time of the founding, and they published a paper on this, and they found that it did not mean what these guys, other people, were saying. Let me go a little bit further here. I actually did a little bit more detail specifically on the Commerce Clause last year, July 8th, 2019. The Commerce Clause in the Constitution, not a power to do whatever they want. I encourage you to check out that detail in full, that episode in full detail when you have a chance. I will link to that in the show notes as well. So what they're doing really is they're defining the word commerce in a modern sense. They're picking up a modern Webster's dictionary, a Merriam-Webster or something like that. Oh, and commerce means such and such. And maybe the word in modern times means that because that's how it's been used in law since the New Deal time. I'm not sure, chicken versus the egg, but the fact of the matter is putting a modern definition on an 18th century legal document doesn't always give you the right results. It may give you the right results for what you want politically, but that doesn't mean it's legal and morally correct. So let's go to a letter that James Madison, the supposed father of the Constitution, wrote to Henry Lee on June 25th, 1824. I've covered this a number of times, especially recently, and he put it this way. If the meaning of the text be sought in the changeable meaning of the words composing it, it is evident that the shape and attributes of the government must partake of the changes to which the words and phrases of all living languages are constantly subject. So if commerce at one point meant just trade, and now it means all gainful activities, if you're putting your modern definition onto the legal document that originally meant trade, you've created a living, breathing constitution. This is what the founders actually rejected. Madison specifically rejected it here as well. He says, what a metamorphosis would be produced in the code of law if all its ancient phraseology were to be taken in its modern sense. So the first place we need to go when we want to understand the original legal meaning of any word, clause, phrase, article, section of the Constitution is to define those words using dictionaries that were regularly used at the time. And sometimes we need to use legal dictionaries as well. And I'm going to include a bunch of links where you can find dictionaries to research words yourself on your own whenever you want to. The first one that I recommend is one from Thomas Sheridan. This is the 1789, A Complete Dictionary of the English Language. I've pulled it up here. It's available to read for free in full on Google Books. I'm sure there's other places if you don't want to use Google, but here it is available for free. So if you just go in here, if you're watching the video here, basically you would just click read for free. And let's pull up the word commerce. Oh, I might already have it up here. I probably do. Commerce. Commixture. Commemorate. Commerce. Where is commerce? I went to government school. My spelling is terrible. Commerce means exchange of one thing for another. Trade. Very simple. Not all gainful activities, not all human interactions. That's defined differently than it was defined in 1789 in the Thomas Sheridan Dictionary, which was one of the most popular, most widely read at the time. So that we know we've got an example. Now, this is not the final research that you would do on this, but you've got one prominent example of how the general public understood the word commerce. And if the people of the several states through the ratifying conventions understood the word this way, and then they approved the document with that legal meaning, that is the legal meaning of the document. That's the legal force. We also have Nathan Bailey's Universal Etymological English Dictionary. I have the 1775 edition here. There's also a 1783 edition. I'm not sure which one was more widely read. I was just able to find the 1775 edition from Nathan Bailey available online for free. And here's commerce, trade or traffic. Also, correspondence, converse. So trade again. Here, from two leading early dictionaries, we also have Samuel Johnson's Dictionary of the English Language. I often recommend something in the 1790s, but I think that's probably a little bit too late because if we're talking about giving something legal effect in 1787, 1788, etc., and then through maybe the ratification of the Bill of Rights in 1791 to really understand how the people understood things at the time, if you use a dictionary that's in the 1820s or later or even around 1800, you may have changing definitions. The same thing that James Madison warned in 1824. And he specifically talked about, let me see if I can pull this one up. He says, all that language of our Constitution is already undergoing interpretations unknown to its founders. Will I believe appear to all unbiased inquirers into the history of its origin and adoption. And he talked about the use of the word consolidate because at the time, a particular word consolidate was talking about one thing and now they meant it a different way. So he already saw this. He warned us about this. And yet most people, when they want to tell us what the Constitution means, they just tell us from their gut. Oh, this word means this. Or they pull up a modern dictionary and they never look back at the historical record to understand what the people who ratified it told us it meant. And here is Samuel Johnson's Dictionary of the English Language, 1785 as well. Commerce. He says intercourse, exchange of one thing for another, interchange of anything, trade, traffic. So again, we're talking about exchanging one thing for another, not all gainful activities, not all human interaction like they want us to believe today, because that gives them the power to regulate anything and everything. And as I mentioned earlier, you can't just use the popular dictionaries because the people who were talking about this oftentimes used legal terms, legal phrases, and sometimes the legal phrases had a little different understanding. The key is, did the people who ratify it understand it in that legal sense as well? So we do a little further research and we can talk about the law. For example, Giles Jacobs' New Law Dictionary, the 1762 version, is probably the one that was most well read by the founders and the founding generation, even those who were not lawyers. I mean, we can talk about people like Theophilus Parsons, James Wilson, John Dickinson, and others, even those who were not lawyers, people like James Madison, were well versed in the history of law. So this one is also another important one to understand and research. I've actually got a whole list of even more that I will include in the show notes at 10thamendmentcenter.com/path to liberty. And again, sometimes when you look through these dictionaries, you'll find a little bit of conflict. Okay, well, this one says a little different, and this one says a little different. So what does it really mean? Which one did they understand it to be? So for that, the follow-up is you really want to look through the state ratification debates. And here's how Thomas Jefferson put it in a letter to William Johnson. This is a guy he nominated for the Supreme Court and served as Associate Justice from 1804 till sometime in the 1830s. This is a letter from Jefferson to Johnson in 1823, June 12th. And he says, on every question of construction, carry ourselves back to the time when the Constitution was adopted. Recollect the spirit manifested in the debates. And instead of trying what meaning may be squeezed out of the text or invented against it, conform to the probable one in which it was passed. In other words, you look through the definitions. If it's not super obvious, don't try to squeeze some definition about it. Go to the state ratification conventions, read through the debates, do the research, do the work, and find out what a particular phrase was understood to mean by the people who gave it legal force, the people who debated it and eventually approved it. Under what understanding did they approve this? And James Madison, in that same letter to Henry Lee, reaffirmed this exact same principle. This was in 1824 again. He says, with a view to this object, I entirely concur in the propriety of resorting to the sense in which the Constitution was accepted and ratified by the nation. In that sense alone, it is the legitimate Constitution. We know that the legal meaning, the original legal meaning of the Constitution is what the people of the several states, the people who ratified it, understood it to mean. Not what Madison's opinion of something was, not what Hamilton, not Jefferson, not any of the drafters, not the framers, not the founders, not the revolutionaries. They were very influential, so if there was a concern about a phrase, they would actually go out and write papers and give speeches and talk about it and help explain. And then when there was a consensus or a general understanding, okay, well, we buy this, then we can get to the bottom of it. Madison goes on, he says, if that not be the guide in expounding it, there can be no security for a consistent and stable more than for a faithful exercise of its powers. So in order to understand the sense of the ratifiers, how Jefferson and Madison told us to look at the Constitution, they told us personally, I'm not making this up, we actually have 5 categories. First of all, we want to look at dictionaries. I gave you some examples. But here from a paper that Nadelson put together, basically a bibliography, we've got a number of others. There's contemporaneous encyclopedias and dictionaries, both English and Latin. Now we know that the founders were well versed in Latin, so if we don't even have any understanding of Latin, they may use a phrase and we may get it wrong because we're trying to interpret something that we don't understand. So sometimes you actually have to look up Latin. This is a lot of work. It's not as easy as what people want it to be. And unfortunately, taking the easy way out has given us the largest government in the history of the planet. Hands down. So dictionaries and encyclopedias from the time, both popular and legal ones, English and even Latin. I don't really do the Latin research. I leave that to other people who understand it. 2, the founding generation's educational canon. So what did they learn? How did they learn? How did they come to their own views, particularly the Greco-Roman classics? I'll get to that in a moment. Evidence of the founders, this is number 3, evidence of the founders' understanding of Anglo-American history, including widely read historical works and pamphlets. 4, the historical records surrounding the adoption of the Constitution. And 5, legal materials, because they were well-versed in law and this was a legal document. These are the 5 things that you need to research beyond just the text of the Constitution, because just reading it, and one example I gave is commerce, if you read it in a modern sense, you're going to be granting the federal government far more power than the founders ever thought of authorizing. They never would have approved ratification had they said the federal government would have power over all human interaction. That was what they feared. That's what they fought a long, bloody war of secession. We're going to be talking on Friday's episode about a number of declarations and resolutions about independence and secession from the Empire of Britain. So we have to have that understanding. So some of these resources, first of all, we've got Eliot's debates. I don't know if I pulled this up. You can actually find these online for free. You've got the debates in the several state conventions. There's 5 volumes where you can read through the several state conventions. Maybe I've got this in, here we go. He says, the founding generation tended to look at the world, I want to go to the Greco-Roman classics, through a classical lens because Greco-Roman writings comprise such a large part of their education. Many of the founders retained a love of classics throughout their entire lives. And I thought this was an interesting tidbit. Patrick Henry, not someone thought of as particularly bookish. And in fact, that's what a lot of people would say about him even today, looking back in history. Oh, Henry, he was a great orator. He really motivated people. We know some of the opposition there in Virginia, some of the people who didn't really like him. I'm looking at you, Thomas Jefferson, didn't refer to him as the smartest guy out there, the most well-read. Maybe because he was more of a people person rather than a legal expert in the way that he spoke. He motivated people, but he actually reread Livy's Roman history every single year. So even the guy at the time that was not known to be very book smart did way more reading of the classics than any of us alive today, probably. Therefore, Rob writes, an originalist scholar needs at least a cursory knowledge of the history of ancient Greece and Rome, particularly of the Roman Republic. Next up, we've got number 3. So Dictionaries, Greco-Roman history. 3, evidence of the founders' understanding of Anglo-American history, like colonial pamphleteers. There are John Adams, John Dickinson, Alexander Hamilton, Stephen Hopkins, James Otis, Josiah Quincy, James Wilson. There are many others. He's got a link here that I will include. This is the pamphlet I'm going to include in our show notes at 10thamendmentcenter.com/path-to-liberty. This is where you can do research over at the Liberty Fund's list for 18th century pamphlets and documents. He also includes pronouncements in the Continental Congress, pre-independence constitutional documents such as colonial charters, and the Articles of Confederation, primarily drafted by John Dickinson, and other state constitutions like the Virginia Constitution drafted by George Mason, or the Massachusetts Constitution drafted by John Adams. Other things like Montesquieu, Locke's of Civil Government, John Adams' Defense of the Constitutions of the United States, and others. And then, of course, we have the historical records surrounding the adoption of the Constitution. This is category number 4. So we've got the records of the Federal Convention, what happened in Philadelphia. So we understood where they came from. So when they made their explanations to the general public, we knew where they were coming from legally. We also can think of things that may have been brought up, like a national veto over all state actions. This wasn't even discussed in the state ratifying conventions, but it was discussed in the Philadelphia Convention. They considered it in something called the Virginia Plan, and they rejected it. And because they considered it and rejected it, we know for sure it's not part of the constitutional powers of the federal government. So the records of the Federal Convention. And Rob says the best source is still the records of the convention from 1787. He says, don't rely only on the ones with Madison's notes. Of course, we need the transcripts of the state ratifying convention. And that's where I pulled up Eliot's debates. There's 5 volumes of this available for free online, totally available. You could probably get it in PDF form and download it as well. Then we also have public speeches, pamphlets, articles on the Constitution, both pro and con. So we've got Federalist and Anti-Federalist papers. We don't want to just look at the Federalists. I know some people out there just want to make every argument about the Constitution based on the Federalists. Now, that's an important thing because we're talking about prominent people, Madison, Jay, and Hamilton, who are advocating in support of the Constitution. You want to understand what the supporters of the Constitution described it to be. But the Federalist was really just primarily written for a New York audience, so it wasn't widely read throughout all the other states. So there's other stuff that we have to read. We also have to read the opposition to understand what they were concerned with and how they understood these phrases to have legal meaning. So here online, again, for free, The Debates in the Several State Conventions and the Adoption of the Federal Constitution, 5 volumes. We also have from the Wisconsin Historical Society, the documentary History of the Ratification of the Constitution. It was first published in 1976. There were 26 volumes, just word for word verbatim of most of the states in 1976. And then over the years, they've been able to transcribe and find even more documents through their own research. And in recent years, we've found additional ones, 2017, 2018, 2019 from New Hampshire, South Carolina, and elsewhere. This is really, really important stuff. And mind you, all of this is if what you are researching is expressly written in the text. That's still answering the first question. So the first question is this constitutional? And you read the Constitution, you look for the text of the Constitution, you try to find the words that match up with the power that's being proposed or being exercised. And then once you think you find it, don't go based on your own personal political view. And if you like it, say, okay, well, it's constitutional. No, then you do this particular research. Sorry, got a lot of work to do. And most people telling you what's constitutional or not are not doing this research. So a lot of times they're either lying to you, they're making stuff up based on their own political views, and they can't be trusted. Sorry, that's bad news, but just the truth. If we want to turn things around, it's going to take some effort here. Now, mind you, this is, again, only if that first question, but we have that second question that Madison pointed out. The second thing that we need to do, and that is, if it not be expressed in the document, the next inquiry must be whether it is properly an incident to the express power and necessary to its execution. If it be, Madison wrote, it may be exercised by Congress. If it be not, Congress cannot exercise it. And I just want to briefly mention the Necessary and Proper Clause episode that I did last July. You should check this out. I go through the details of the doctrine, the legal doctrine that the founders understood of principles and incidents, something that Madison specifically mentioned here in 1800, whether it is a proper incident to an express power and necessary to its execution. It's not necessarily easy stuff, but it's important to understand how they understood it. I also want to point out one other thing. My buddy Joe Wolverton, who we've published here at TAC for a long time, and he's been writing for the New American for a long time, another number of other publications. He's got a great book on Madison's Federalist 46. I think he's working on probably a few more to follow up at this point. But he texted me last night, and Joe, I love you, man. I'm not sure if you're watching the show, but it's pretty cool. The fifth category that I didn't mention is legal resources, and we can actually look through this here. Legal materials used at the time of the ratification. And Rob says a strong majority of leading founders were lawyers. Even among non-lawyers, legal knowledge was also very widespread. And legal arguments were common public fare in the debate over ratification. Yet, much of what passes for originalist scholarship treats legal sources skimpily, relying on little more than Coke and Blackstone. Great opportunities await writers willing to cast their nets further. So we have to look at legal dictionaries, legal treatises. And here's how Joe has been doing a lot of great research and work on the original sources that the founders relied on. We can go back into the 17th century, the early 18th century to understand some of the most important documents, books, and the like that they read. And he says, check this out from Vattel's Law of Nations. He says, hey, I saw you're doing a podcast in the morning on how to read 18th century legal documents. I don't know if I sent you this before. You haven't? But this comes from Vattel's book, The Law of Nations. Book 2, Chapter 17, Section 272. Interpretation of ancient documents. And it's fascinating how Madison used that exact same phrase, ancient documents, ancient phraseology, when he was writing to Henry Lee in 1824. He certainly was well-versed in the Law of Nations, so he understood that ancient legal texts had to be read in a certain way. And Joe quotes this. He says, when therefore an ancient document is to be interpreted, we should be acquainted with the common use of the terms at the time when it was written, and that knowledge is to be acquired from documents of the same period, from contemporary writers by diligently comparing them with each other. This is the only source from which to derive any information that can be depended on. This is what Vattel wrote in Law of Nations under the chapter on interpreting ancient legal texts. And that's exactly what Jefferson and Madison understood. This is what people like Dickinson and Wilson and Tench Coxe and others who were well-versed in the law would have understood. We know how the founders approached an old legal document, and now the Constitution is a pretty old legal document to us. Vattel goes on. Again, this is the only way. The use of vulgar languages being, as everyone knows, are very arbitrary. Grammatical investigations pursue with a view to discover the true import of a word in common usage would furnish but a vain theory, equally useless and destitute of proof. And Joe says, doesn't get much clearer than that. He provides several rules. He could send me all of them. And I encourage, Joe, if you check out this episode, please do. I have not really studied that stuff. And that is a weak spot in my own research and something that I need to improve on. So thank you so much. Everyone should check out Joe Wolverton's work, which is pretty awesome as well. Well, let's take a look over at the live chat. I hope you guys are finding this interesting. It's pretty heady stuff. If you like geeking out on the Constitution, or you just want to know stuff, or you want to know how you're supposed to learn stuff, and you can call people out for saying, like, there are things that I know I have studied specifically. I haven't studied every word and phrase in the Constitution, but there are things that I know that I have studied, and I've gone through the original legal meaning of something, and then someone tells me that, oh, no, this is what it means, and here's why. And common sense, all I did was read the document. Here's what the words are. That's what you need to do. I don't need to be a lawyer. No, you don't need to be a lawyer. The founders never wanted everyone to have to be a lawyer, but they did use legal phrases in a legal document, and people were they were much more well-read than we are today, reading our 200 some odd characters, and that's it. So they were reading this stuff. The general public was oftentimes reading this stuff and understanding it, or wanting to learn about it as well. So there's been so many times where I've been told, like, oh, okay, well, this phrase means this. And I'm like, I know 100% you are personally making this up. And I try to be nice at first. I'm like, well, where did you learn this? And almost invariably, every single time, I'll get called some kind of a commie or a libtard or something if it's someone on the right who doesn't like the fact that I'm opposing centralized power or federal power on a particular thing, or it's other terms like racist or whatever if it's somebody from the left. So they are almost always making it up. Generally, you don't have this type of conversation with people from the left because they only care about the Constitution when it fits their political narrative, and they're happy to throw it out when it doesn't. But then again, the right does the same thing. It's just that they continue to pretend that they're upholding the Constitution. They'll just twist and fit whatever meaning will go into it. And what was that phrase? That was Thomas Jefferson who told us, don't do this. I want to see if I can pull this one up again. Here we go. Carry ourselves back to the time when the Constitution was adopted. And instead of trying what meaning may be squeezed out of the text, that's exactly what they're doing all the time. And unfortunately, most people are really willing to do this because what they care about first is their own political narrative or supporting their team or their individual at whatever level of government, and they really don't care about the history and the truth. But we can actually bludgeon them with the truth here and there and maybe work towards the Constitution, decentralization, and advancing liberty. All right, I'm going to take a quick look in the live chat and see if Funky Euphemism says, even in law school getting my JD, I don't think we spent more than 9 hours total on constitutional law. And I know, and I've heard from other people like Kevin Gutzman and many others, like they don't teach you the ratification debates. They don't teach you original source documents. They say, this is what the Supreme Court said starting in 1803-ish, and this is what the Constitution means because the Supreme Court is the final ultimate authority. D. Wise, thank you again for all your work. Looking forward to the episode on Friday. Blue North, thank you, Michael, and guys for giving me stuff to learn on top of at the TAC. Fuzz T. Fork said, my IQ jumped almost tenfold today. I guess you guys are into this. Aaron Wright says, and they can't be trusted 100% of the time in my experience. And yeah, and unfortunately, and even when I'm telling you stuff Not that I'm even more trustworthy, but I'm willing to tell you guys, like, look, here's how you figure it out yourselves. It's not just we got to own the libs or we got to own the right, whatever. It is about getting to the truth of it. And what is constitutional and unconstitutional doesn't necessarily always fit with our own political goals. But when it doesn't, or when we can't get the federal government to start or stop doing something, then we should focus on our states and state constitutions and localities. That's the way the founders wanted it. And that's the way to ensure that when you screw something up, you don't screw it up for anyone and everyone. You need to write a good book, says Ryan Lopez. I'm going to leave the book writing to everybody else, unless he was saying that to somebody else. I got enough on my hands, buddy. That's a tough one. Infinite Perimeter says now submitting dystopia. I'm not sure what that one's. Devin Watson, the argument of Scalia was that the necessary and proper clause allows Congress to regulate those things that have substantial effect on interstate commerce. And I know that, and I'm not sure if I actually covered Scalia's opinion on this, but this is a stretch. And of course, we saw conservatives do that in the Raich case in 2005 because they didn't like the product that the federal government was going to try to prohibit. And then, of course, they're going to change that view later on in the NFIB versus Sebelius case. We don't want to get too much into it. Joanna Martin posted the 1828 dictionary, and that actually is too late. The 1828 dictionary is very easy to find. This is Daniel Webster. Mind you, a lot of people really we'll say federalists, those who supported real federalism at the time, saw Webster as a nationalist. So I'm not sure if there was a nationalism or a centralization, a consolidating power type of tinge to the dictionary that he wrote. But 1828 is too late because it can't have an impact on the legal understanding of those who drafted and ratified the Constitution in the late 1780s. It was just, unless it's time traveling, it just can't happen. So you can look at it, and I think it's actually good to look at because it's so popular and so many people who talk about the Constitution's original meaning. I don't know why, but I always see Webster's 1828 dictionary, maybe because until recent years that was the one you could find. But it's good to look at it because that helps us understand where they're coming from. But then we have to compare it to how the founders and the ratifiers, the people of the several states, what dictionaries did they use? Because they weren't using an 1828 dictionary in the summer of 1788 in Virginia. I can guarantee you with that. Fuzzy Fork says, never put your trust in man. Exactly. And Patrick Henry in the Virginia ratifying debates in June of 1788, and I'm paraphrasing it, he really basically said the same thing. He said, show me that age and country, any time in history, when the people put trust in their rulers being good men. And that was his phrase, rulers being good men without a subsequent loss of liberty. And he said, every single time you trust people with power with your liberty, you're guaranteed to lose it in the long run. Mike Gangstead, great comment. We can't uphold liberty without knowing the truth. It's in our best interest to know. And it takes a lot of work. And Wyatt says, you're teaching us how to fish, not just giving us fish. And I guess that's really what it gets down to. Because, I mean, I can't do all this work. One person, I have been able to set up an organization that has reached hundreds of thousands, if not millions of people. But there's only a limit of what I can do 24 hours a day. And we need more and more people doing this kind of work. And the more information on how you can do it, you could literally set up a website dedicated to researching one particular clause or one particular phrase, blogging about it. I don't know if you want to geek out like that. Maybe a lot of people think it's boring, but the more that people do things like this, the more that we can reach more people with the truth, because truth heals. Gina Hardin says, Noah Webster, first dictionary of the American language, not British. But if it's 1828, again, it's still too late because they weren't using an 1828 dictionary in the state ratifying conventions, whatever that dictionary may be. Let me take a look at Webster's 1828 dictionary. Noah Webster's word of the day. Yeah, there it is online. You can find it. And again, you may find a lot of good stuff, and it's far better than using a Merriam-Webster than in current times, but you certainly cannot rely on it for the original legal meaning of the Constitution. You have to know the language of the period to understand what the founders meant on the limitations of government. John Thomas Absolutely correct. Well, I'm going to look back at the live chat a little bit later and the comments in the archive a little bit later. I'll reply to as many as I can, but I do read all of them. So if you support the show, please continue leaving some comments, whether it's live or in the archive. Smash the like button, subscribe, get bell notifications. All that stuff triggers the algorithms of the platform you happen to be on, whether you watch or listen. Reviews on iTunes and elsewhere, it does the same thing. And it tells the platform to show the program to more people. So you're basically helping us do paid promotion, but for free. So do all that stuff. It really helps us get the message out to more and more people. And of course, if you really support us and you want to back us financially, I see a bunch of people out here who are members, and I cannot thank you enough. I appreciate everyone here. I don't want you to feel obligated to join us financially, support us financially, but if you're able to and you think we're doing good work, I hope you'll consider a membership. 10thamendmentcenter.com/members, where you can support us for as little as $2 a month. Or if you want to do a one-time donation without joining up, it's 10thamendmentcenter.com/donate. Again, I hope you enjoyed this episode. On Friday, we're talking Declaration, we're talking independence, we're talking 3 great resolutions from 1775, 1772, and 1776, and a speech later in August, early August, after the Declaration, a few weeks later. And I'm going to cover that on the Fast Friday edition. So I'll see you then. I hope you have a great day. I appreciate you being here, and I'll see you next time here on the Path to Liberty.